Okay, welcome to Finals or Rise. The African Court of Justice and Human Rights is now in session. President Catherine Pena and the Honorable Judges, Professor Nilam and Dalia and Mr. Swalehe Mendiwengo as our observant judge. The case before the court is the situation in Uzuri. The parties are the Office of the Prosecutor versus the Defense, Ms. Lusho Mongala. The prosecution and the defense are each allocated 35 minutes to present their pleadings. Over to you, Madam President.
Thank you. We're ready for prosecution one.
May it please this honorable court. My name is Sande Sharif, appearing on behalf of the prosecution with my co-counsel, Nasije Gloria. In 10 minutes, I will be submitting on the first issue as to whether the charges against Ms. Lusho Mongala are admissible before this court. In 22 minutes, my co-counsel will classify the nature of the conflict and will submit on the second and third issues. Your Honor, with your permission, I'll proceed with my submission on issue one.
Sure.
In regard to the first issue, pursuant to Article 28A of the Malabo Protocol, this court has jurisdiction to hear this matter. When addressing the first issue,
Counsel, what's the difference between jurisdiction and admissibility?
Thank you very much, Your Honor. Jurisdiction is the power of the court to hear the case, whereas admissibility refers to the case that the court can hear. So it means the court can have the power to hear a case, but the kind of case may not be the court may be not supposed to hear that case.
So which one is first, and can you tell me the source of what you just said?
Thank you very much, Your Honor. Jurisdiction is first. The court determines that it has jurisdiction first. Then the second question is whether the alleged, whether the charges are admissible before that court. And in the case at hand, we're relying on Article 28A of the Malabo Protocol, which gives this court jurisdiction to handle cases, and among those cases, specifically paragraph 3 are war crimes. And in regards to admissibility, as the prosecution, we're going to rely on Article 46H, both clause 1 and clause 2. I'll proceed with my submission. Having considered that this court has jurisdiction to hear this matter, when submitting on the first issue as to whether the charges against Ms. Lusho Mongala are admissible before this court, I will make two head arguments. One is the complementarity principle, and the second one is the threshold of sufficient gravity. In regard to complementarity principle, I would like to refer this court to Article 46H of the Malabo Protocol, which gives this court the power to complement national courts and courts of regional economic integration. In the decision on the prosecutor's request for an authorization and investigation in regards to the situation in Georgia, paragraph 39, it was held that when the court is to exercise its complementary jurisdiction, it has to make an assessment as to whether there are any ongoing proceedings.
I think there's a problem.
Clerk, could you pause the time? I think prosecution one has been disconnected for technical issues.
When the court is exercising its complementary jurisdiction, an assessment has to be conducted as to whether there are ongoing proceedings in the national court. Your Honor, in the present case, there are no ongoing proceedings in the national court. If I may refer this court to paragraph 28.
But isn't that principle, it's only on the ongoing proceedings? Or maybe the possibility, just the possibility of a proceeding to exist in those domestic jurisdictions?
I beg your pardon, Your Honor?
But that complementarity principle, it's only regarding the ongoing proceedings, or could it also be applicable if there's just a possibility that any domestic jurisdiction court has jurisdiction and it's admissible over the matter?
Thank you very much, Your Honor. The complementarity principle, as I've stated in the decision on the prosecutor's request for an authorization of an investigation in regard to the situation in Georgia in pretrial chamber 1 at paragraph 39, it was held that court has to make an assessment as to whether there are ongoing proceedings in the domestic court. So an assessment has to be made if there are any ongoing proceedings in the domestic court, Your Honor. And in this case, Your Honor, there are
Can
no
you
any
tell me
ongoing
another
proceedings.
sort, or which is the standard before the International Criminal Court? Is it the same?
I beg your pardon, Your Honor?
Is the same as you're saying before the ICC, or can you tell me any other sources of different courts that are saying that they have to be ongoing?
I've relied on the ICC, Your Honor.
Can you name me any other court?
In the pretrial chamber 1 of the ICC, that is in the decision of the authorization of an investigation in regards to the situation in Georgia, pretrial chamber 1 of the ICC. Furthermore, in my submission, having fulfilled the complementarity principle, I would therefore like to also submit on the second part of admissibility, that is on sufficient gravity. Your Honor, in regard to sufficient gravity, in the case of prosecutor versus Samoei Ruto, that is in the pretrial chamber 1 at paragraph 62, it was held that in assessing sufficient gravity, 2 criteria must be followed. One is the quantitative criteria, and secondly is the qualitative criteria. The quantitative criteria was defined in the case of prosecutor versus Abu Ghida in the ICC pretrial chamber 1 in 2009 at paragraph 82 to mean the number of victims. Your Honor, the case at hand has 37 deaths and 42 injuries, and that is on paragraph 21, the last line. Furthermore, on paragraph 25, the last line, there are a number of deaths of civilians that were a number of deaths of civilians. This means that we have already, as the prosecution, met the quantitative criteria because it only looks at the number of victims, as defined in the case of prosecutor versus Abu Ghida. In regard to the qualitative criteria, yes, Your Honor.
So you're making reference to the jurisprudence in Abu Ghida case, but the court in that case does indicate that also it is determined on a case-to-case basis, and also can be seen by the jurisprudence of the same court, the pretrial chamber in the Mavi Marmara case, where the number of casualties was higher and the court said it was not of sufficient gravity. So what are the circumstances in this case on the number of the victims that would make it to have sufficient gravity?
Much obliged, Your Honor. Like you have stated, indeed, the test of sufficient gravity is applied on a case-by-case basis. And that is why, as the prosecution, we have referred to the number of deaths in this case as 37 and 42 injuries, and that is on paragraph 21, the last line. However, Your Honor, when determining sufficient gravity, it's not only...
I'm sorry, can you tell us any source or any case in which, with a less amount of kills and injured people, the court has ruled that the admissibility criteria is fulfilled?
Thank you very much, Your Honor. In the case of prosecutor versus Abu Ghida, that is in pretrial chamber 1 in 2010, in the ICC pretrial chamber 1 in 2010, it was court held that 12 deaths and a further attempt to kill 8 had already met the sufficient gravity test. Proceeding to the qualitative criteria, Your Honor, the qualitative criteria was defined in the case of prosecutor versus Al Hassan in the appeals chamber at paragraph 91 to mean the nature, the scale, the degree of participation of the accused, and the resulting impact. I will handle the scale. The scale is determined from a weight spread. Weight spread was defined in the case of prosecutor versus Omar Hassan at paragraph 82 to mean the number of victims that have the number of victims of the attacks. Indeed, the number of victims of the attacks, Your Honor, are on a wide spread in this case, because at paragraph 21, the last line, 37 deaths were recorded, and 42 injuries were also recorded, and including other unknown number of deaths.
Counsel, could you please remind me and remind the judge that is there any other criteria of sufficiency, gravity, other than those numbers or the qualitative qualitative criteria? Is there any other thing? Because I have enough hearing numbers from you.
Much obliged, Your Honor. I would straight away go to the scale. The scale is recorded in terms of the systematic occurrence of the case, or systematic occurrence of the attacks.
Okay, much better.
In regards to the scale, thank you very much, Your Honor. In regards to the scale, it is recorded on the systematic occurrence of the attacks, and the attacks must have occurred with no probability. That means they must have occurred in a planned and must have also occurred in a pattern. They must have not occurred randomly or in a probability, as provided in the case of prosecutor versus Kodik in the appeals chamber of the ICTY at paragraph 94. In regards to the case, Your Honor, these attacks indeed were systematic. I would like to refer this court to paragraph 22, the second lane, where the Kadibonya Armed Forces were looking for grounds on how they can strengthen their forces. And what did they do, Your Honor? They went to Ms. Lushomongala, requested if she has any program that would help them in that regard. In separate talks, Ms. Lushomongala accepted that indeed she has an add-on program that would help these Kadibonya Armed Forces. What does that mean? It means that the government had a plan. Which plan it looked how it can execute it. It went to Mr. Lushomongala, who is the CEO of Asoirama, and having got the add-on,
for me, you're just tying those things, separate things up to make that plan. But for me, it's not clear the existence of that plan. Can you tell me specific facts of the case that can support what you're claiming?
Much obliged, Your Honor. I refer this.
Madam President, his time is up. Probably if you'd award him a few minutes to answer your question.
Yes, one more minute.
Much obliged, Your Honor. To answer your question, I've relied on the facts that is in paragraph 22 at the first lane, whereby the Kadibonya Armed Forces were looking for grounds on how to strengthen their forces. What did they do, Your Honor? They reached out to Ms. Lushomongala, whether she can develop a program that would help them strengthen their forces. It means this was already a plan after seeing that they have a weakness. And indeed, Ms. Lushomongala, in separate talks, accepted to give them the add-on I. And we see the results of add-on I in paragraph 25, the last lane, where we had a known number of civilians dying. And that already shows that this was in a systematic manner. Lastly, Your Honor, the degree of participation of the accused. It is the prosecution's submission that the degree of participation of the accused was a high degree, as can be inferred from the facts that is in paragraph 22, the first lane, that she in secrecy, she accepted and provided add-on to the Kadibonya Armed Forces. Furthermore, in paragraph 19, the 5th and 6th lane, we see that bad target A1 would collect data, send it to Asoirama. Asoirama would process this data and send it to the Kadibonya Armed Forces. Not forgetting that at paragraph 6, the first lane.
Sorry.
Thank you, Counsel.
If Madam President will allow me to pose a question in regards to the argument that the oralist is making on the degree of participation. Now, considering that the only function of Ms. Lushomongala is the creation of the AI, and then the AI was given to the Kadibonya government. So if all the AI was given and run by the Kadibonya government, why then would Ms. Lushomongala be the one who has the highest responsibility in this matter?
You have one
minute.
Much
obliged, Your Honor. Much obliged, Your Honor. As I've already referred this court to paragraph 19, line 5 and 6 of the brief facts, where, for example, the bad target would collect data, send it to Asoirama, and paragraph 6, line 1 of the brief facts, it is stated that Ms. Lushomongala is the CEO of Asoirama. It means the data would be sent to Asoirama. Asoirama would then send the data to the Kadibonya Armed Forces. That is why, as the prosecution will say, that her degree of participation is high. Furthermore, in the brief
But
facts,
sorry, Council, but that information was being given to the Kedibonyi Armed Forces, and the Kedibonyi Armed Forces had commanders who were giving orders. Why not hold those commanders responsible? The only function of Mr. Mongala is to create the AI, but who gives the order? Who is responsible are the commanders of those armed forces. So don't you think they are the ones who have the highest responsibility in this matter?
Much obliged, Your Honor. There is no gravity requirement that requires one to be charged to be in war crimes to be a commander or an army officer, as stated in the case of prosecutor versus Intaganda. So that is why, as the prosecution, still we stand on our ground that Ms. Mongala still had a high degree of participation. If it was not because of the data that she gave to the Kadibonyi Armed Forces, these alleged war crimes would have not been committed. This is because, as we see in the facts, and that is paragraph 14, the fifth lane, the Kadibonyi armed government would still not handle the high number of, would not still host the high number of people. And it is because of this is because of Mr. Shomongala, according to the government with the program, that it helped them to confine the people. And that is why we're saying, as prosecution, her degree of participation was irrespective of her not being a commander or an army officer, Your Honor.
Thank you, Councillor.
Much obliged, Your Honor. With that, I would like to give the floor to my co-counsel to submit on the second and third issues.
Thank you, Councillor. We're ready for prosecution number 2.
May it please this honorable court, my name is Councillor CJ Gloria, as earlier introduced by my co-counsel, appearing on behalf of the prosecution, and I'll be classifying the armed conflict and addressing issue 2 and issue 3. With the permission of this honorable court, I would like to proceed and classify the armed conflict. In the instant case, there existed an international armed conflict. And if I may refer this honorable court to common article.
I'm sorry, just to be clear, how many armed conflicts are there?
Two forms, Your Honor. That is the non-international armed conflict and an international armed conflict, Your Honor.
So both are international armed conflicts?
An international armed conflict is defined under Common Article 2 to the 4 Geneva Conventions as a conflict that arises between 2 or more states. And in this instant case, if I may refer this honorable court to paragraph 16, line 4 of the Moot problem, it is stated therein that the Salima armed forces crossed the border and clashed with the Kidibonyi armed forces for about an hour. And at that point of time, the conflict existed between 2 states, that is the state of Kidibonyi and the state of Salima. Hence, it amounted to an international armed conflict. And
from what time to what time does that international armed conflict exist?
I beg your pardon, Your Honor?
From what time to what time does an international armed conflict, or that international armed conflict that you're explaining, exists? From what time? From when to when?
It exists as long as the conflict is between 2 states, Your Honor. And it
so
is,
how can we define when an international armed conflict is over?
For example, if I may refer this honorable court, paragraph 4 of the Moot problem, that is in regards with the occupation, that an occupation is provided for under Article 2 still of the Common Article 2 to the 4 Geneva Conventions. And in view, the occupation was really shown under paragraph 4, where the occupation existed between 1975 to 2000, Your Honor. And the control under occupation takes 2 forms, that is effective control and overall control. And Your Honor, although the effective control existed in Kidibonyi between 1975 to 2000, and later the Kidibonyi armed forces withdrew from Kidibonyi, from Uzuri, still there was overall control, Your Honor. And overall control is seen when the Kidibonyi armed forces have the overall and ultimate control over Uzuri through the de facto government And this was shown where the Kindimbonyi Armed Forces had the authority or implemented the overall authority over Uzuri through the local police force, Your Honor. Proceeding, Your Honor.
Sorry,
Yes.
Counsel, I have two questions on that. First, you make reference to paragraph 16 of the fact sheet in regards to the conflict between Salima and Kedibonyi in order to invoke international armed conflicts. But does that mean then, if that's when the conflict started, the unlawful confinement submission that you intend to make as a war crime happened prior to that? That means there was no armed conflict, therefore there's no war crime.
Your Honor, the confinement occurred not before, but it was after. If I may refer this Honorable Court, paragraph 15, line 4, line 2 of the Moot problem, the confinement occurred in April, Your Honor.
Yes, it occurs in April, May 2022, and paragraph 16 in regard to the conflict between Salima and Kedibonyi started in June 2022. So that means confinement was before in April, and then the conflict started in June.
Yes, Your Honor.
The confinement was not at the time when the conflict started, it was before. That means it does not then arise to become a war crime.
No, Your Honor, as I had earlier stated, in regards with occupation, even after these armed forces, the Kindimbonyi government withdrew from Uzuri, they still had overall control over Uzuri. That is through the de facto government, Your Honor. And
well, that now brings me to the second question. If that is your submission, then take into consideration paragraph 5 of the fact sheets that then Uzuri was given an autonomous, both legislative and administrative autonomous, and was being governed by Europe. Don't you think then in that situation, it became an autonomous region and it was not under the effective control of Kedibonyi?
Yes, no, Your Honor. If I may respond to your question, that the Europe was a smaller group of minorities that was unrecognized, and there was absence of consent or direct consent from the Europe. Therefore, Your Honor, at that point of time, there was still an overall control.
Well, sorry, but well, the reason why Europe was allowed to govern it is through an agreement between Europe and Kedibonyi government. They had an agreement, and then they allowed significant legislative and administrative autonomy, and then Europe was given to govern the region. And therefore, there was no effective control anymore after 2000 when Kedibonyi armed forces withdrew. Europe was in total control. And therefore, that means there was no occupation.
No, Your Honor, I agree that the effective control was not in existence. However, the overall control through the de facto government was in place, Your Honor, as it is provided for that a local government can consent to the end of occupation. However,
now sorry. So if you are saying there is overall control, is it a requirement for occupation to have effective control or to have overall control?
It can be either of the two. It can be either effective control or overall control, Your Honor.
What is your authority?
According to what source?
Your Honor, according to the case of prosecutor versus paramilitary. Proceed.
Sorry, prosecutor versus
agent.
In the case of prosecutor versus a paramilitary, Your Honor.
Before which
before which court was that?
It was, Your Honor, it was between two states, Your Honor. It was a conflict that was existing between two states, Your Honor.
Which state and which state?
Yes. It was the state of it was the state of USA, Your Honor, and the state of just a second, Your Honor, I consult with my co-counsel.
No, I'm sorry, Counselor. Can you please proceed?
Yes, Your Honor. Proceeding to substantiating on issue 2, that is whether there are whether during the said armed conflict war crimes of unlawful confinement attacks against plant protected persons, and attacks against...
Agent, I'm sorry, before you move on to that question, is there any non-international armed conflict in the present case?
And no, Your Honor, it was... No.
None.
No, Your Honor.
There wasn't any, maybe what you can call a rebellious group that has caused injuries and that has a threshold of organization? None.
No, Your Honor, it was only an international armed conflict.
Okay,
if I may have a follow-up question on that, what about the attacks being made, the conflict between ULF and the Kedibonyi government?
Yes, Your Honor. Under paragraph 2, the state of Uzuri had already voted in unification with Salima, and they were already under the state of Salima, Your Honor. And the conflict between the ULF and the Kedibonyi government was now at that point between two states, that is the residents of Uzuri, who are a part of Salima, and the Kedibonyi armed government, Your Honor.
So,
it was between
so is a conflict between residents of a certain country against another state's and international armed conflicts?
No, Your Honor.
So what kind of conflict is that? If civilians or if you call members or citizens of a certain country pick arms to fight against another government, what kind of conflict then is that?
It is an international armed conflict, Your Honor.
And what's your authority
between
for
two
that?
states? Between what states?
Just responding to Your Honor's question, the authority is additional protocol 1 at article 2.
Which paragraph of article 2 of additional protocol 1 provides that if civilian picks arms and fight against another state, it becomes an international armed conflict?
Your Honor, it is under article 1, paragraph 4, Your Honor.
Under article 1, paragraph 4, it talks about if there is wars of national liberation or against colonial domination, racist regime. So is that the case in this situation?
No, Your Honor. However,
Counsel, could you please answer me in a very quick answer? So you categorize the conflict between people to a certain state. You consider this as an international armed conflict, or no?
Your Honor, it was between the ULF, which is a non-governmental group, an organized armed group, and the state.
Yeah. So it is an international armed conflict or none?
It is an international armed conflict, Your Honor.
Well, then I am confused, because on your first statement earlier, you mentioned that the criteria for an international armed conflict is between state and state.
Yes,
so
yes, Your
which
Honor.
one is your stance? Which one is your stance?
Your Honor, it is yes between the two states, Your Honor. And at this point of time, the ULF armed group, an organized group, are residents of Uzuri and are part of Salima, which has the sovereignty over that region. So it was between two states, that is the state of Salima.
So how do you, then will lead to my second question. How do you attribute this group with the state? Is there any attribution? How do you connect this?
Yes, Your Honor. Under paragraph 16, still under paragraph 16, it is indicated therein that the Salima Armed Forces threw the RPG to the ULF, Your Honor, during this conflict between the two states. Proceeding, Your Honor, to addressing issue 2, dealing with whether the war crimes of unlawful confinement, attacks against plant protected persons, and attacks against protected property were committed in Uzuri pursuant to Article 28D. In addressing this issue, the prosecution will make 3 head arguments. That 1, the confinement was unlawful, and the prosecution will rely in the cases that have set 2 elements for it to amount to unlawful confinement. That is the case of Prosecutor versus Dario Kodik and Mario Saz, that was decided in the Appeals Chamber of ICTY in 2004 under paragraph 73, and the case of Prosecutor versus Delalik and others that was decided in the Appeals Chamber of ICTY in 2001 under paragraph 302. That the 2 elements are, to begin with, is the first element, when a civilian or civilians have been detained in contravention of Article 42 of the 4th Geneva Convention. And Article 42 of the 4th Geneva Convention.
And what does the 4th Geneva Convention regulate?
Yes, Your Honor. It protects civilians during an armed conflict, Your Honor. Proceeding, Your Honor, to stating what is in Article 42 of the 4th Geneva Convention, Your Honor, it is provided therein that the internment or placement of protected persons in an assigned residence may only be ordered if it makes the security of the detaining power absolutely, Your Honor. And for it to be absolutely necessary is if it poses a threat to security. And in the instant case, the acts of the Uzurian residents did not pose a threat to security. If I may refer this Honorable Court, paragraph 15, line 2 of the Moot problem, the Uzurian residents were only expressing their support for the ULF and also campaigning for reunification with the state of Salima, Your Honor, and they were not engaging in any act of violence.
Can you please repeat the fact that you're quoting?
Paragraph 15, line 2 of the Moot problem, Your Honor.
And so in regards to paragraph 15, line 2, if I may, your argument is, well, the civilians in Uzuri were not participating in the conflict, but rather they were just showing support to ULF.
Yes, Your Honor.
But the same fact does indicate that the ULF is a terrorist organization under the Kedibonyi law. So what do you expect a government to do to supporters of a terrorist organization? Don't you think that arresting them because they're supporting a terrorist organization is within the powers, especially they're not parties to the conflict, they're just civilians. So that means they are subject to the laws of that country.
And
yes,
just a follow-up question to that question. What does a terrorist group, how is a terrorist group defined? And do you consider that that definition is fulfilled?
Your Honor, in response to the first question, under Article 19, Clause 1 of the ICPR, that is the International Covenant on Civil and Political Rights, it provides that everyone shall be entitled to freely hold their opinions without interference, Your Honor. And that freedom was interfered in this instant case, as they were only showing expressing their opinions by supporting the ULF, Your Honor.
But Article 19 has provisions of exceptions in case of public safety or national security. Now, considering them being terrorist an organization and they're supporting that terrorist organization, don't you think it's a challenge to public safety and therefore it falls within the exceptions?
No, Your Honor, it would have only amounted if they were taking part in acts that were violent, Your Honor. But in this point of time, they were only expressing their support. And the exception here, it does not fully fill the exceptions that are provided for under Article 19, Clause 3 of the ICCPR, Your Honor. Proceeding to responding to the second question posed by Madam President, at this group of the ULF, this group of the ULF are not terrorists. You are not terrorist groups, Your Honor. As for one to amount to a terrorist group is where they are conducting acts that are prohibited within the laws of the state. But although they were conducting this act, Your Honor, they were still only showing that they wanted to have a unification with the state of Salima, Your Honor. And also under Article 1, Clause 4 of Additional Protocol 1, it provides that the people can also engage in acts where they are trying to provide self-determination. And in this instant case, they were also striving for the self-determination to be a part of Salima, Your Honor, continuing to addressing.
But
Sorry,
Councillor,
Council. Okay. Madam President,
Councillor, what happens when there's no domestic law that penalizes terrorism, but there's still a terrorist act? Then that terrorist act can never be judged?
No, Your Honor, then it can be governed by the Martens Clause. Proceeding, Your Honor.
Now, my question comes in regards to the same aspects. But paragraph 4, line 6 of the fact sheet does indicate that ULF was considered a terrorist organization under the Kedibonyi law. That means there was a national law that was governing that.
And Your Honor, yes, although there was a national law, and as I had earlier stated, Your Honor, that these are residents of Salima, and they are not bound by the laws of the state of Kindimbonyi, Your Honor. Proceeding to.
But in what country was the possible crime, if we ever get to consider that there was a terrorist crime? In what country was that? Did that crime happen?
Pardon, Your Honor?
In what country did those things happen? In what country? Not the nationality of those people, but in which territory?
Maybe we would regard that in regards with the Kindimbonyi government, because the Uzurians were already residents and a part of citizens of Salima, and them conducting those acts of attacking the Uzurian residents, it would maybe amount to the terrorism, Your Honor. Proceeding to addressing the second element, that is that when a civilian or civilians have been detained in contravention of Article 43 of the 4th Geneva Convention. And Article 43 of the 4th Geneva Convention provides for procedure safeguards, Your Honor. And indeed, the prosecution agrees that these procedure safeguards were met under paragraph 15, line 10 of the Moot problem, as the reviews were conducted 3 months, Your Honor. However, these two elements are cumulative. The first element is when a civilian has been detained in contravention of Article 42, and when they have been detained in contravention of Article 43 of the 4th Geneva Convention. And although Article 43 has been satisfied, the elements of Article 42 have not been met, Your Honor. Hence, the confinement was unlawful, and the offense of unlawful confinement pursuant to Article 28D, Clause A, Paragraph 7 of the Malabo Protocol were committed in Uzuri, Your Honor. Proceeding to addressing the second element, the attacks were directed at protected persons. And under Additional Protocol 1, Article 51, Clause 2, it provides that civilians shall not be an object of attack. And under Article 51, Clause 3 of Additional Protocol 1, Your Honor, it provides that they shall only be an object of attack if they are taking part in direct hostilities. And if I may refer this Honorable Court, paragraph 27, line 7 of the Moot problem, it is the gunners that opened fire. And as they opened fire, it prompted the Uzurian residents to throw stones in self-defense, Your Honor.
So, before the gunners opened fire, the civilians had done blocking of the advancement of the Kedibonyi forces. And if we are to use the ICRC interpretative guidance, it does indicate blocking as an example of a situation where civilians are taking direct part in hostilities. So don't you think in this situation, they were taking direct part in hostilities?
No, Your Honor.
Council, Madam President, if you could award the Council a few minutes to answer the judge's question.
You have 1 minute, Councillor.
Yes, Your Honor. Under the interpretative guidance of the ICRC on the notion of direct participation in hostilities, it has set 3 cumulative criteria that all must be met. And the first one, that if the act is likely to adversely affect the military objectives or capacity of the military. And the second element is when is of causation, Your Honor. And in the instant case, the act of the civilians, yes, the prosecution agrees that they threw a stone at Lieutenant Kamo. However, it did not meet the threshold of harm, the adversely affecting the military objectives, Your Honor. And thirdly,
sorry. My issue is not even throwing of the stones. My issue is the blocking first, even we reach the words. And the same document you're making reference to has made an example of blocking as taking directly taking part in hostilities. The same ICRC interpretive guidance that you're making reference to. So that's where my issue is.
Yes, Your Honor. In response to that, if I would refer this Honorable Court to the previous paragraph of that line, Your Honor, paragraph 26, it is indicated on the last line that previously there was a demonstration, and when the government peacefully requested the residents to leave, they were able to evacuate. And even at this point of time, if they were able to come and do the same thing, conduct the warning, they would have peacefully left that place, Your Honor.
Sorry. What happened is when they blocked, Lieutenant Kamau Zongo came down to try to negotiate with them. So there was an initiation of negotiation by Lieutenant Kamau Zongo.
Yes, Your Honor, and the prosecution does not object to that. However, during the course of the negotiation, the gunners opened fire at the building. And at that point of time, the civilians, as they believed that they were the exact target, pursuant to paragraph 27, line 7 of the Moot problem, they threw these stones, Your Honor, and at that point, the belligerent nexus was not met. And the belligerent nexus provides that when the conduct of the civilians is aimed at supporting one group at the detriment of the other party. However, the belligerent nexus is different when the conduct of the civilians is on self-defense, and this is provided for under page 61 of the ICRC's interpretative guidance, that when it is on self-defense, then it will not amount that they are taking part in direct hostilities if they pick up weapons or other means, and it is necessary and proportionate, Your Honor. And in this instance case...
Sorry, lastly on that. So if they picked arms to fight against the Kedibonyi government on self-defense, don't they become levy en masse in this situation and therefore fall within the category of combatants pursuant to Geneva Convention 3?
No, Your Honor, it was...
If civilians pick arms in order to defend their territory, then they become levy en masse and they are considered as combatants.
Yes, Your Honor. However, in this act, it is specifically as an act of self-defense. And the ICRC's position was very clear on the act of individual self-defense, Your Honor, that if the act is done as an act of self-defense, then it will not amount to direct participation in hostilities. And they did not end there. They went ahead to state that if this attack is necessary and proportionate, Your Honor. And if you look at the throwing of stones, it was necessary, but it was not proportionate to equate it to the gunners that would open fire, Your Honor. Therefore, it is the submission of the prosecution that the throwing of stones was an act of self-defense and the attack against protected persons was violated in this instant case, Your Honor. I so beg to proceed, Your Honor, and address the last
thank you,
head
I think your time is up, right?
Okay, yes, Your Honor.
I think so. Can you please confirm?
Yes, Your Honor, but I would request this Honorable Court to kindly permit me if I will be able to proceed and address the other matters. Madam President?
No, Counselor, your time is up.
No.
Thank you.
Okay, Madam President. Much obliged.
No? I'm sorry, who said no? Is not her time up?
No, I mean, it's not allowed to do that because it won't be fair for the other group.
Okay, thank you, prosecution team. Now we move on to defense number 1.
Good afternoon, Madam President. Your Honors, may it please this court.
Thank you, Counselor. I'm sorry, I don't see you. Do you have your camera turned on?
Yes.
Yes, his camera is on.
Okay, is the other judges are seeing him?
Yes, we can see.
Yes, we can.
Okay,
Yes.
maybe it's just me. Thank you. Proceed, Councillor.
Good afternoon, Madam President, Your Honors. May it please this court. My name is Yusuf Jamiu. I appear together with my co-counsel, Mustafa Awau, on behalf of the defendant, Ms. Lushomo Ngala. I'll be addressing this court for 15 minutes, after which my co-counsel will speak for 18 minutes. We respectfully reserve 2 minutes for sub-debater. Your Honors, the prosecution has brought this matter before the Honorable Court to confirm charges of war crimes against the defendant, Ms. Lushomo Ngala, and they have raised 3 issues for determination before the Honorable Court. The defense submits that this court cannot confirm charges of war crimes against Ms. Lushomo Ngala. To justify our submission, we will address the 3 issues raised by the prosecution in this case. I'll speak on the first issue, which borders on the admissibility of this case, as well as the nature of armed conflict, while my co-counsel will speak on the second and third issues, which revolve around the commission of war crimes in Uzuri and the individual criminal responsibility of Ms. Lushomo Ngala for the war crimes charge. Your Honors, I'll proceed to make my submission on the first issue. The first issue is whether the case against Ms. Lushomo Ngala is admissible before the AFCJHR. The defense notes that this issue is bifurcated into the jurisdiction of this court and the admissibility of this instant case. On the jurisdiction of this court, the defense concedes and has earlier submitted by the prosecution that this court has jurisdiction to entertain this matter in line with Article 3 of the Malabo Protocol. Your Honors, the concession of the defense to the jurisdiction of this court is premised on 3 grounds. Firstly, the subject matter of this case, which is war crimes, as can be gleaned from paragraph 30 of the Statement of Yes, Your Honor.
Counsel, could you please remind me why do you think that this court is the correct court to judge this matter? Why not going to other international courts such as ICC? Why?
Your Honors, the parties to the conflict have ratified the Malabo Protocol. Hence, they can come before this honorable court to institute the matter. It is contained as paragraph 31 of the Statement of Agreed Fact that the Republic of Salima has ratified the Malabo Protocol as well as the Kenimboe. Hence, this court is the appropriate venue to institute this matter. Proceeding with my argument.
Proceed.
Proceeding with my argument, Your Honors. The defense concedes to the jurisdiction of this court premised on 3 grounds. Firstly, the subject matter of this case, which is war crimes, as can be gleaned from paragraph 30 of the Statement of Agreed Fact, falls within the crimes listed in Article 28A of the Malabo Protocol, thereby conferring this court with jurisdiction rationale material over this matter. Secondly, as envisaged by Article 46E of the Malabo Protocol, the crimes charged were committed after the entry into force of the Malabo Protocol. Your Honors, paragraph 31 of the Statement of Agreed Fact discloses that the Malabo Protocol entered into force in 2019. Furthermore, a community reading of paragraph 15, paragraph 21, and paragraph 26 of the Statement of Agreed Fact reveals that the war crimes charged were committed in 2022. Hence, this court has jurisdiction rationale temporis over this matter. Lastly, Your Honors, as envisaged by Article 46E bis of the Malabo Protocol, this court has jurisdiction rationale personnel over this matter because the crime charged were committed on the territory of the Republic of Salima, who is a party to the Malabo Protocol. Your Honors.
Counsel, sorry. Were the crimes committed on the territory of Salima or were committed in Uzuri? Or is it your submission that Uzuri is a territory of Salima?
Uzuri is part of Salima, Your Honor.
And how do you substantiate that, considering that Uzuri had both significant legislative and administrative authority and was being governed by Europe?
Your Honors, if I may refer this noble court to paragraph 2 of the Statement of Agreed Fact, what happened was merely a military occupation of Uzuri by Kendiboye. Your Honors, this act does not make Uzuri part of Kendiboye. And as the ICRC has provided in their publication on the situation in Israel and the occupied territory, it was held that notwithstanding how long a military occupation lasts, it doesn't make that part a territory of the state. More so, Your Honors, it was more so, Your Honors, the commentary on the first Geneva Convention provides that an occupation can be direct or physical. Your Honors, what happened herein was merely an occupation because the Kingdom of Kendiboye has their police force in charge of Selima, and also they have access to Selima at any time they think fit. Hence, it is a submission of the defense that Uzuri is part of Selima and was never part of Kendiboye.
So I understand your submission in regards to that, but my issue is, after the conflict arose between Selima and Kediboni, then there was an occupation. But then after the occupation, the territory became an autonomous territory that had its own governing body, which was Europe, and had its autonomous both legislative and administrative. So don't you then think that then it becomes a separate territory from both the two countries of Kediboni and Selima?
No, Your Honors, it doesn't become a separate territory. As can be gleaned from the statement of agreed fact, majority of the people of Uzuri voted to align themselves with Salima when the Kingdom of Bukada decided to end colonization of Selima. Your Honors, for a country to be sovereign, most part of it must align with the government of the day. It can be discerned from statement of agreed fact that the Europe are the minority and not the majority. Your Honors, this act does not make Uzuri an independent territory. Hence, it is the submission of the defense that Uzuri is part of Selima. Proceeding with my argument, Your Honor, notwithstanding the fact that the defense concedes to the jurisdiction of this court, it is our humble submission that this jurisdiction is not exercisable because this case is not admissible before this honorable court. Your Honors, Article 46H, paragraph 2 of the Maloro Protocol has set out conditions to be satisfied before a case can be admissible before this honorable court. Firstly, the state that has jurisdiction must be unwilling or unable to prosecute or investigate the accused. And secondly, the case must be of sufficient gravity to justify further action by this court. It is the submission of the defense that none of these conditions were satisfied. Your Honors, on the first condition, which is that the state that has jurisdiction must be unwilling or unable to prosecute or investigate the accused. Herein, Your Honors, two states has jurisdiction. First, the Republic of Salima, because the crime were committed on our territory. Secondly, the Kingdom of Bukada also has jurisdiction because the defendant is a national of that state. Your Honors, the prosecution were erroneous of this fact, and they only argued the inability of the Republic of Salima to prosecute. Your Honors.
Counsel, sorry. Why
Yes,
then will the obligation arise on Bukada when Bukada is not even a party to the protocol that creates this court? So does the unwilling or unable criterion apply to Bukada?
yes,
And I'm sorry, Agent, a follow-up question also. What if, I mean, there are no ongoing proceedings? So what tell us that those governments are willing to have those judgment?
Madam President, answering your answering your question first, as envisaged by Article 46H, paragraph 3, a state will only be declared unwilling to prosecute if reasonable time has lapsed and they did not investigate the defendant. Herein, the crime were committed in October 2022, and the matter was brought before this court in April 2023. Your Lord, this is a period of 5 months, and such period does not constitute a reasonable time for this court to conclude that the Kingdom of Bukada is unwilling to prosecute. And turning to the question of Your Honor, which borders on the fact that Bukada has not ratified the Maloro Protocol. Your Honors, firstly, Your Honors, the ICC in the prosecution versus Apre Yekato provides that where it is yet to be ascertained that a state that has jurisdiction is unwilling or unable to prosecute the defendant, the pretrial chamber is under obligation to invite such state to make submission to that effect. Herein, the Kingdom of Bukada can make submission if this court allows it.
Sorry, the jurisprudence of the ICC in that case was making reference to state parties, not states that are not party to the Rome Statute.
Your Honors, that's what is leading me to my second fold of my argument, Your Honors. Under Article 46, under Article 3, Paragraph 2 of the Malabo Protocol, a non-state party can consent to the jurisdiction of this court. Hence, if this court invites the Kingdom of Bukada to make submission, the Kingdom of Bukada can consent to the jurisdiction of this court and make submission to that effect. And if they are unwilling,
sorry. Article 23 of the Malabo Protocol only allows a state that is not, pardon?
Article 3, Paragraph 2.
Yes, it does allow a non-state to become to accept the jurisdiction of this court on a temporary basis for the specific period of time that they were. But the state of Bukada has not done that.
Yes, Your Honor. If this court had made an invitation to Kingdom of Bukada to make submission on whether they are willing or unwilling to prosecute, they might have done that. And that is the essence of the complementarity principle, Your Honors. It makes the jurisdiction of this court secondary to that of the national court. Your Honors, in light of this, we submit that the complementarity principle has not been complied with. In the circumstance of this,
what about B? Sorry, what about Paragraph B of 46H?
Paragraph B is to the Paragraph B of Paragraph B provides three conditions. Your Honor. The gravity, secondly, that the state that has jurisdiction is unwilling or unable, and thirdly, that the conduct that forms the subject matter of this court has not been litigated before any other court. Your Honors, proceeding to the issue of gravity, having satisfied this court that a country that has jurisdiction might be willing to prosecute. Gravity of a case, as declared in the ICC in the case of the prosecutor versus German Kantanga, is assessed from both the quantitative and the qualitative perspective. Your Honors, the prosecution has failed to satisfy both perspectives in the circumstances of this case. On the quantitative perspective, the ICC held in the prosecutor versus Abu Ghraib that
Counsel, could you please elaborate? What is the importance? What is the significance of gravity with regard to this court?
Yes, Your Honor. Thank you, Your Honor. Your Honor, the essence of gravity is to ensure that this court only determines serious crimes. And Your Honor, the seriousness of a crime is determined from the means used as well as the number of victims. This is in line with the preamble of the ICC. Your Honors, if I may proceed, in the prosecutor versus Abu Ghraib,
Counsel, your time is up. Unless you request Madam President to.
Madam President,
I would like to. I'm not sure. Sorry, Madam President, if you can hear us.
Yes. I lost you for a bit, but now I can hear you.
Well, I recommend for fairness, since we had added certain minutes to the prosecution, we should do the same amount of minutes for both defense 1 and defense 2. So maybe the clerk would guide us in terms of the time that had been extended for prosecution 1, for us to also extend it to defense 1.
1 minute.
Proceed, Counselor.
Your Honors, on the qualitative perspective, it is, Your Honors, the gravity of the case is measured from both the quantitative and qualitative perspective. The quantitative perspective denotes the number of victims of the crime. Here in paragraph 21 discloses that 37 civilians were killed. However, Your Honors, this death cannot be considered in the assessment of the quantitative threshold of gravity here. This is because these civilians partook in hostilities, and the ICC commentary on direct participation in hostilities has ruled out protection for civilians who engages in hostilities. Hence, their death cannot be considered in the assessment of the quantitative threshold of gravity hearing. On the death of unknown medical staff and patients, Your Honors, the ICC held in the prosecutor versus Ali Hassan 2020 that in the assessment of the quantitative threshold, at least an approximate number of the victims should be disclosed. Your Honors, as can be gleaned from paragraph 26 of the statement of agreed fact, it was only stated that unknown numbers of medical staff and patients were killed. Hence, this death can also not be considered in the assessment of the quantitative threshold of gravity. Hence, the
Counsel, if I may interject, What about the aspect of the degree of participation of the defendant in this situation? If Madam President will allow the council to answer my question. Yes.
Sure.
Your Honors, as declared in the ICC 2003 paper on some policy issue before the office of the prosecutor is only allowed to bring individuals of greatest responsibility before this court. Your Honors, the defendant is not of greatest responsibility to the crimes charged herein. Firstly, this is because she did not take part in the use of the warfare, or she did not authorize the use of the warfare in Uzuri. And Your Honors, in the ICTY case of the prosecutor versus Boskowski and Takulovsky, Your Honor, where similar thing ensued. In that case, Your Honors, the defendant was acquitted of the charges against him because the court found that he had no control over the police that detained the Bosnian Muslims.
Counsel, sorry. In that regard, then, you made reference to the ICRC commentary when you are making an argument on the quantitative aspect. But the same ICRC in their commentary on the guiding principles of the usage of lethal autonomous weapons has indicated for the developer's liability of the autonomous weapons. And therefore, since Ms. Lushomo Ngala in this situation is the developer, don't you think then the responsibility also triggers to her?
We are aware of the ICC position on autonomous weapon system. However, Your Honors, we wish to revert the mind of this court to Article 36 of the Additional Protocol 1. It provides that when new weapons are used in warfare, it is the responsibility of the high contracting state to ensure that these new weapons are in compliance with IHL guidelines. Herein, Your Honors, it is disclosed in the statement of agreed fact that all information about this autonomous weapon were transferred to the Keniboye government. Hence, it is the responsibility of the Keniboye government to ensure that they are IHL compliant before they deploy them in warfare. And it is in light of this that we submit that the participation of Ms. Lushomo Ngala is not of high degree to justify further action by this court. Turning to the nature of armed conflict, Your Honors, we submit that this case is an international armed conflict. However, the defense notes that a non-international armed conflict existed in the statement of agreed fact. As can be gleaned from paragraph 16 of the statement of agreed fact, this Republic of Salima dropped RPGs to Uzuris, to ULF fighters in Uzuris, and they collected these RPGs to attack Keniboye. Your Honors, this act of Republic of Salima internationalized the existing non-international armed conflict between ULF and Keniboye state government. And it is
what's the requirement of the internationalization of the conflict from non-international armed conflict into an international armed conflict? And I also take note that your time is up, so you should just wrap up that and then move on to the next oralist.
Your Honors, to internationalize a non-international armed conflict, the high contracting state only needs to show support for the armed group. And in this case, it can be gleaned from...
What's your authority for that?
Your Honors, the ICRC, Your Honors, if I may, the ICRC commentary on internationalization of non-armed conflict provides for it at exactly paragraph 16. Yes, Your Honor.
Well, the ICRC commentary does not say that. Actually, the ICRC does indicate that there is application of the overall control test and the effective control test, but in determination of individual criminal responsibility, then the effective control tests, the overall control test should apply. So whatever you are saying is not under the commentary.
We are aware of what you just stated, Your Honors, the effective test and the control test. For to be clear, Your Honors, the ICRC are in support of the control test. And the control test in this regard applies where there was no NIAC initially. But herein there was an existence of NIAC between ULF fighters and Keniboye government. The mere support of Republic of Salima internationalized it into an IAC. And it is on this note that I will defer proceedings to my co-counsel, who will address this court on issue 2 and issue 3 respectively. Thank you, Your Honors.
Thank you, Councillor. Councillor 2 of the defense, you can proceed.
Madam President, Your Honors, may it please the court. As earlier introduced, I am Mustafa Hawa, and I'll be addressing issues 2 and 3 on behalf of the defendants, Ms. Lushomo Ngala. Our submission will go on to demonstrate that the prosecution has failed to establish that the war crimes of unlawful confinement, intentional attacks against plant protected persons, and attacks on protected objects were committed in Uzuri. And in any case, the prosecution has circumvented an entire military hierarchy and instead targeted an innocent individual who in this regard provided cutting-edge technology to suit the request made by the Kedibonyi government. To this end, the defense shall prove before this court that the war crimes of unlawful confinement, intentional attacks against plant protected persons, and attacks on protected objects were not committed in Missouri, and that Ms. Lushomo Ngala did not incur individual criminal responsibility. If it pleases Your Honor, the defense would like to proceed with their submission. As to the first charge,
Councillor, before you proceed, I have a follow-up questions on what Councillor 1 of the defense said. The first one is, if we determine that there is a non-international armed conflict, which are the parties to that non-international armed conflict? And the second one is that the Councillor 1 mentioned regularly the ICRC comments. What's the legal value of those comments?
Your Honors, with regards to your first question, we submit that the parties to the non-international armed conflict involve the ULF and the Kedibonyi armed forces. And in response to your second question, we also submit that the ICRC commentaries is persuasive in nature in view of Article 31 of the Malabo Protocol, which recognizes publicist opinions. May I proceed, Your Honor?
I have a follow-up question on that in regards to the first question from Madam President. So if your submission is the parties at the ULF and the Kedibonyi government, is it your submission that ULF are it's an armed group, not members of a state?
Your Honors, we submit that Uzuri is part of Selima, but the ULF constitutes an armed group. Proceeding with my argument, Your Honors, as to the first charge of
Agent, do you consider that there are certain requirements for an armed group to exist? Which are they, and do you consider that they are fulfilled?
Your Honors, in response to your question, the requirement is that there must be an organization of the armed group. And Your Honors, from the statement of agreed fact, we observe that the ULF has adequate hierarchy, a proper hierarchy. Proceeding with my argument.
That's the only requirement?
No, Your Honor. The second requirement involves intensity.
Which is the standard of intensity?
This standard of intensity was clearly stated in the trial chambers case, the decision of the trial chambers in the ICTY case of the prosecution versus Tadic, 1997.
And what was the standard stated? In that case, there was a standard. There was a particular word that set out the standard of that requirement. Do you remember which one is it?
In response to your question, Your Honor, we submit that the standard as stated in the prosecution versus Tadic 1997 is that the conflict must have lasted for a lifespan, for a long lifespan.
And do you consider that requirement is fulfilled?
Yes, Your Honor. We consider that this requirement has been fulfilled in the instant case.
Proceeding
with my argument, as to the first charge of unlawful confinement, the defense submits that this war crime was not committed in Missouri based on the sole grounds that Article 42 and Article 43 of the Fourth Geneva Convention have been duly complied with. Now we understand that the prosecution has sought to establish before this court that two cumulative conditions must exist for a confinement to be lawful, and in the instant case that these conditions have not been fulfilled. However, it is our contention that both conditions have been fulfilled. Your Honors, Article 42 of the Fourth Geneva Convention clearly states that the confinement
Counselor, what does the First Geneva Convention regulate? What's the subject matter of the First Geneva Convention?
Your Honor, I did not get that.
What is the First Geneva Convention regulate, or what is it about?
The First Geneva Convention regulates, it recognizes the wounded and sick, and it provides for their amelioration of the wounded and sick in field, Your Honor. Proceeding with my argument, we submit that the condition as outlined in Article 42 of the Fourth Geneva Convention has been validly met. Your Honors, we submit that the civilians' engagement in direct participation in hostile activities falls into the category of serious security threat. And for this, we place heavy reliance on the opinion paper of the ICRC titled Internments in Armed Conflicts, Basic Rules and Challenges, particularly at page 4, paragraph 4. Your Honors, it would interest this court to know that what amounts to direct participation in hostilities has been outlined by the ICRC interpretive guide on the notion of direct participation in hostilities, wherein three cumulative conditions were outlined. One of such conditions is that the act must reach the required threshold of harm, and we submit that this first condition has been met in the instant case. Your Honors,
Counsel, could you remind us why this court needs to obey or needs to take consideration on the ICC commentary? Why? Counsel?
Clerk, could you pause the time? I think counsel has been interrupted.
Honors, can I be heard?
Yes.
Yeah, so I repeat my questions. Counsel, can you hear me?
Yes, Your Honor, I can hear you now. I apologize for the network.
Okay, that's okay. So I repeat my questions. Could you please remind us, the judges, why shall we consider the ICRC commentaries for this court?
In response to your question, Your Honor, we refer to Article 31 of the Malabo Protocol, which provides that judicial decisions could be taken into consideration, Your Honor.
The ICC comment, the ICRC commentaries. The ICRC commentaries.
Your Honor, with respect to the ICRC commentary, we also place reliance on Article 31 of the Malabo Protocol, which provides for the persuasive nature of publicist opinion. Your Honor, these commentaries are persuasive in nature and they are not legally binding. Proceeding with my argument, we submit that the conduct of the civilians by organizing protests which turned out to be violent, erecting road blockades, throwing stones and projectiles at police officers, evident at paragraph 8, lines 6 to 8 of the Statement of Agreed Facts, clearly shows that they adversely affected military operations as they prevented the Kedibonyi armed forces from ensuring national security. We submit with respect
Counsel,
to the
sorry, at this moment, because your colleague had argued that there was existence of a non-international armed conflict that was later internationalized by the support from Salima. So at this time, what was the conflict? What was the character of the conflict during the confinement point?
Your Honor, at this point, it has internationalized into an international armed conflict, as it is evident.
But when you make that reference, the support by Salima happened later on in June 2022. The confinement was even before that, in April. So how then could it have internationalized when the support had not been given at this time?
Your Honor, prior to this, there had been the existence of military occupation by the Kedibonyi armed forces.
So if you are saying that by virtue that there was a military occupation, but then that military occupation ended in 2000. In fact, in 2001, that's when the Kedibonyi military withdrew. And therefore, when this happened, there was no occupation anymore.
Your Honor, from the Statement of Agreed Fact, we observed that at this point, the ULF launched attacks at the Kedibonyi government, and the Salima also provided support to them. Proceeding with my...
Which paragraph of the fact does indicate the support by Salima?
Paragraph 16 of the Statement of Agreed Fact, Your Honor.
Thank you. But paragraph 15, before we read paragraph 16, paragraph 15, that's when the confinement happened, which was in April and May 2022. The support happened in June 2022. That means the confinement happened even before the support came in. Meaning, if we borrow the submission of your colleague, it means that at this moment it was still non-international armed conflicts. Is that the submission?
Yes, Your Honor, we submit that at this point there was the existence of an NAIC.
Then if that's the case, how then does Article 42 of Geneva Convention apply? Or what are the laws regulating non-international armed conflicts?
Your Honor, Common Article 3 and the Additional Protocol 2 regulates non-international armed conflict.
Then if that's the case, how then are you invoking Article 42? And if that's the case, is there a war crime of unlawful confinement and a non-international armed conflict under the Malabo Protocol?
Your Honor, we submit that the Malabo Protocol provides for the war crimes of unlawful confinement.
But only under international armed conflict, not under non-international armed conflicts. So if at this time there was a non-international armed conflict, why then do we have a war crime of unlawful confinement?
Your Honors, the burden of proving this lies on the prosecution. We submit, Your Honor.
Yes, but the prosecution said this is all an international armed conflict. They are not the ones who says it's a non-international armed conflict. It was your submission that it is an international armed conflict.
Your Honors, in response to your question, we submit that there was the simultaneous existence of the NAIC and an IAC, and eventually this NAIC internationalized into an IAC. Proceeding with
following the previous questions, do you think there is existence of war crime under national law, or does war crime only exist in international law?
Your Honors, it exists under national laws as well.
As well. So, in domestic law, war crime also exists?
Yes, Your Honor, under domestic criminal law. Crimes generally...
No. A war crime. I'm talking about war crime. So war crime, I repeat my question. So war crime exists both in international law and national law?
Your Honors, war crimes exist only in international armed conflict, Your Honor, of international nature.
Okay, proceed.
Proceeding with my argument, we also submit that the third condition of the existence of a belligerent nexus is present and has been successfully met. Your Honors, making reference to paragraph 9, lines 1 to 6 of the Statement of Agreed Fact, it reveals to us that the act within this context is the incitement of the ULF via the use of Asadat, a social media app, and the likely harm, which is the eventual resistance of the ULF to the Kedibonyi Armed Forces. Having established this, we also submit.
Again, please stop the clock.
The HR rules on internment have been.
We lost you for a bit, Counselor, but please proceed.
Yeah.
Your Honors, we submit that the IHL rules on internment has been validly met in the circumstance of this case. One of the rules is rule on treatment of the internees, and we submit that there is no fact on there's no evidence on the facts on the face of the fact sheet showing that these persons were subjected to torture, inhumane or degrading treatment, or subjected to scientific or medical experiments. On the second rule, which is the rule on material conditions of the internees, we also submit that in line with paragraph 15, lines 5 to 6 of the Statement of Agreed Facts, these confined persons were allowed and were provided access to food, medical appointments, and even recreational activities. Now, moving on to the second condition, in view of Article 43, we understand that the prosecution has already submitted that this condition is present, and we place reliance on paragraph 15 of the Statement of Agreed Fact, which states that an administrative court conducts the review and its decisions could be appealed against up to the apex administrative court. On the whole, we submit that these two cumulative conditions in view of Article 42 and Article 43 of the Fourth Geneva Convention have been complied with, and that this war crime was never committed in Missouri. Moving to the second charge of intentional attacks against planned protected persons, it is our submission that this war crime was not committed in Missouri, as these protected persons lost their protection by taking part in direct participation in hostilities, and that the principle of distinction and precaution as required by customary IHR rules.
Counsel, first I have concern with regard to the status of civilians. Okay, because although they are throwing rocks, but that does not equal to the treatment to the other parties, which is using weapon, because we have an issue of proportionality with regard to this. So what you're saying about this? Don't you think that the civilian still needs protection?
Your Honors, in response to your question, we submit that as at the time of the attack, The civilians' initial barricade of Old Town Plaza validly constitutes a direct participation, an act of direct participation in hostilities. Your Honors, as was held in the case of the prosecution versus Jean-Paul Akayesu, it states that an examination of the case is to be carried out in order to consider if at the time of the alleged offense, the victims did take part in hostilities. And as we have clearly submitted, the civilians, by initially constituting that barricade, have already lost their protection as they adversely affected military operations of the Kedibonye Armed Forces, to be specific, from accessing the buildings which housed a ULF soldier with an RPG.
Sorry, so you are invoking the blocking part to be direct participation in hostilities, but the requirement of the blocking should be one that will trigger the military advantage of the other forces not to be able to be made. But do you think that the civilians blocking in any way defeated the military advantage of the Kidimoni forces?
Yes, Your Honor. We submit that the 250 civilians, particularly constituting that barricade in front of Old Town Plaza, amount to direct participation in hostilities, as they prevented the Kedibonye Armed Forces from accessing the building which housed a ULF soldier with an RPG.
Well, what the fact says, actually, because the fact says they did not even know the building has until when they were trying to negotiate. Lieutenant Kamau Zongo was trying to negotiate. That's when the gunners detected. So they didn't even know that there was a ULF soldier there.
Your Honors, we submit that from the statement of agreed fact, the ULF soldiers distributed pamphlets to the civilians, urging them to block these streets, Your Honors. And as such, they had the proper prerequisite information that this there was a presence of a ULF soldier in the building. Proceeding with my argument, Your Honor. On the third condition, we also submit that there exists a belligerent nexus between the acts of the civilians in supporting the ULF to the detriment of the Kedibonye Armed Forces. Your Honors, we observe a direct causation, the act and the likely harm in view of the distribution of pamphlets earlier stated to the ULF, urging them to act of the civilians deliberately placing themselves in front of this building, hence making them and identifying them as a target.
Counsel, as far as that argument is concerned, your argument is that yes, there was supply of pamphlets and all that, but that only shows a nexus. The requirement is belligerent nexus. So how then do you prove the belligerent part of it?
Honest.
Counsel, I think there's a problem with your network.
Also constitutes an act of direct participation in hostilities.
We couldn't hear your
Can I be heard, Your Honor? Can I be heard now, Your Honor?
Yes.
Your Honor, there exists a belligerent nexus as the act of the civilians deliberately blocking these streets acts as a
I think we lost her.
form of support ULF to the detriment of the Kedibonye Armed Forces accessing the building which housed a ULF soldier with an RPG. Proceeding with my argument, we submit that the principle of precaution and the principle of distinction has been validly met in the instant case. With respect to the principle of precaution, we understand that bird targets may become overloaded when the range of individuals exceeds 50. However, the gunners operating bird targets took this warning into consideration as they opened fire only 8 seconds after it was identified. This is evident at paragraph 1, 9 to 10.
I'm sorry, did you count the additional minutes that you gave the prosecutor?
Okay, 1 more minute.
Okay, I'm sorry, Counselor, you have 1 more minute.
Proceeding, Your Honor, we submit that bird targets only opened up fire 8 seconds after detecting threat as against the usual 3.5 seconds within which it would have opened threat. We also observe that the principle of distinction has been clearly met as ADOM and bird targets were built specifically to distinguish between ULF fighters and combatants, as well as to recognize the ULF distinctive emblem in order to prevent attacks on civilian and civilian objects. Now moving to the individual.
But Council, it couldn't do that when there is a big population of more than 50 people. So how then do you expect it to react when there is 250 civilians?
Your Honor, we have submitted that bird target, the gunners operating bird targets took this warning into consideration and opened fire only 8 seconds after identifying threats as against the usual 3.5 seconds. Now,
a sufficient precautionary measure?
Your Honor, yes, we have to take into consideration the circumstances of the case. We have to take into consideration the fact that there are about 250 civilians pelting stones at the armored vehicles in conjunction with the fact and the possibility of the ULF soldier RPG's bullets reaching these gunners within infinitesimal seconds. Proceeding with my argument.
But the facts do not indicate that. The facts indicate that the first attack was against the building where the ULF had an RPG. But then, of course, the second attack, which was against the civilians who were throwing stones. So those are two different. Now, in this situation, automatically, it couldn't do a distinction by virtue that the people had exceeded the number that it was programmed to do. Then whose fault is that?
Your Honor, as we have earlier submitted that these gunners took adequate precautions, however, we submit that in view of Article 36 and Article 57 of the Additional Protocol 1, the high contracting party is conferred, who in this case is Kedibonye government, is conferred with the responsibility of ensuring that the weapons to be used comply with the internationally agreed limits and that they do not intentionally attack civilians and civilians.
But reference to Article 36 is only on state responsibility, not on individual criminal responsibility. So when it comes to individual criminal responsibility, there is a totally different criterion, which that's why the ICRC comes under the person who has been able to produce. Did you get my question?
Honest, I didn't get.
I did not get. Sorry.
Could you come again, please, Your Honor?
Yes, let me repeat. You invoke Article 36. Article 36 is only in regards to state responsibility for violation of international humanitarian law. That's why it is on the high contracting states. But when it comes to individual criminal responsibility, it has a different standard of application because not all violations of IHL amount to war crime. Oh, I think she has a technical issue.
Councillor, do you hear us?
Your Honor, I can hear you now.
Okay.
Okay, so I'll just, I will ask my question again. So my question is, you invoke Article 36, but Article 36 isn't specific to state responsibility. That's why it requires high contracting states to do that. But when it comes to individual criminal responsibility, which is what we are dealing with here, applies different standards. And therefore, don't you think in this situation, it goes back to the person who developed as far as individual criminal responsibility is concerned?
Your Honor, can I be heard?
Yes.
In response to your question, we submit that Ms. Lushomo Ngala is merely a software developer and her role ended the moment she handed over the AIs to the Kedibonye Amphus, and she did not give the orders to directly attack these persons.
Well, lastly, because your time is up, so lastly, if she's only a mere developer, the same ICRC you're making reference to has indicated that in situations of lethal autonomous weapons, then the developer has a liability of the autonomous weapons. So in that situation, if the fault is as a result of the development of it, then responsibility arises on the developer. Now, since in this situation, the fault is as a result of the development because it could not do a distinction for more than 50, then that's a developer problem, and therefore developer liability comes in.
Your Honor, in response to your question,
Counselor, can you hear us?
I think she cannot.
Yeah.
She's disconnected.
They have just got in touch. They're having some network glitches, so they're just trying to sort it out.
Okay.
Your Honor, can I be heard now?
Yes.
In response to your question, we submit that from the statement of agreed fact, bird targets may become overloaded. And however, it did not specifically state that bird targets launches indiscriminate attacks when it becomes overloaded. It simply says that it takes longer time to access the identified targets. Proceeding with my argument, Your Honor, we submit that Mr. Shomongala did not incur individual criminal responsibility.
I think your time is up.
I see that my time has lapsed, and for this, we rely on our written submissions for Mr. Shomo's individual criminal responsibility. Unless I may be of any assistance to the court, may it please the court.
Thank you, Counselor. Okay, so now we are going to deliberate, right?
Well, we have rebuttals and rebuttal.
Yes. Please, the prosecution team can please proceed with the rebuttal.
Yes, Your Honor, the first rebuttal is thus the defense has submitted that the quantity, that the number of the death does not matter. However, in the case of prosecutor versus Abugada, the death of 12 and the attempt to kill 8 was considered to amount to sufficient gravity. And in regards with discussing on the qualitative, the prosecution has submitted on the degree of participation. However, they have not disputed that the prosecution submissions on the scale, nature, and intent of the accused during the commission of these offenses, as the prosecution has submitted, and they have shown that there was intent to commit these crimes as depicted in paragraph 22, line 1 of the Moot problem, Your Honor. And the second rebuttal is the defense have agreed with the prosecution that indeed there existed a military occupation. And it is during that time when the offense of unlawful confinement was committed, Your Honors. And this military occupation is governed under the 4th Geneva Convention, Article 2, Paragraph 2. And that the military occupation played a significant role in the confinement. Hence, the offense of unlawful confinement was committed in Uzuri during an international armed conflict, Your Honor. And the other is the defense alleged that the civilians had lost their protected status. However, as the prosecution had earlier submitted that they were only acting in self-defense as provided for under the ICRC's interpretative guidance, and the act of blocking stones only happens in a civil unrest, and that's what they were conducting. However, they had not lost their status, Your Honors, as submitted by the defense. Proceeding to the other point, the defense submitted that Ms. Lisho Mangala was only a mere developer and she is not liable. However, the prosecution submits that Ms. Lisho Mangala is individually liable for aiding the commission of the offense of unlawful confinement, attacks against plant protected persons, and attacks against protected property pursuant to Article 28N, Paragraph 2 of the Malabo, of the Malabo Protocol, Your Honor. And an aiding is defined in the case of prosecution versus Jean Paul Akayesu as giving assistance to someone. And the provision of AFROC by Ms. Lisho Mangala enabled the confinement. And the provision by Ms. Lisho Mangala of the bad target enabled the Kendimboni government to be able to achieve their military objective, that is the one of attacking the ULF. And that is clearly seen under paragraph 27, line 6, when the gunners indicated that there was a possible ULF in the process, hence the military objective was met. And the other is the principle of proportionality was violated in this instant case, which is governed under Article 51, Clause 5, Paragraph B of the Additional Protocol 1, which provides that where it is expected to cause incidental loss, injury to civilians, and damage, or a combination, which, yes, which will be excessive.
Your time is up.
Much obliged, Your Honor.
We're ready for the sub-rebuttal of the defense team.
Your Honors, I'll proceed to make the sub-rebuttal for the defense. The prosecution has raised 3 issues. Firstly, the quantitative perspective, and I will address that first. Your Honors, the prosecution cited the ICC decision in the prosecutor versus Abu Garda. Your Honors, the fact of that case is not what is cited before the Honorable Court. Your Honors, in that case, the quantitative and qualitative threshold of gravity was not considered. What was before the ICC was the evidence before the court, and on that basis, the ICC held that the case against Abu Garda was inadmissible because there was no substantial evidence to justify the claim of the prosecution before the ICC. The fact that 12 deaths was reported and 8 injuries, Your Honor, this does not mean that the ICC held or laid down a prerequisite that those amounts of death and injuries satisfy the quantitative threshold of gravity. Turning to the qualitative threshold, Your Honor, we have earlier submitted that the degree of participation of the defendant is minimal, and the essence of the ICC and the prosecution office is to ensure that the individuals who bear the greatest responsibility are brought before the ICC. Where the individual bears a minimal responsibility, the prosecution can only ensue national jurisdiction to pursue such individuals, and this is provided for in the ICC paper policy on the office of the prosecution. Your Honor, turning to the charge of unlawful confinement, Your Honor, we have earlier submitted that the civilians lost their protections by virtue of the ICRC commentary on direct participation in hostilities. It can be gleaned from the statement of Abrifa that these civilians mounted barricades. They also expressed support for ULF fighters. Your Honor, this act, and as contained in ICRC commentary, is to the effect that they took direct part in hostilities. Your Honors, on the individual criminal responsibility of Ms. Lisho Mangala, Your Honors, the prosecution failed to establish whether she had the requisite mens rea or not, and this is essential to the success of individual criminal responsibility. Aside that, Your Honors, What the defendant merely did was to supply autonomous weapons to Kenny, which is our own choice of living, Your Honors. And Article 36 of the Additional Protocol 1 confers responsibility on the high contracting party to ensure that these autonomous weapons are in compliance with internationally agreed limits. In this case, it can be said that Ms. Lucio Mongala incurred any individual criminal responsibility in respect of the war crimes charge. Hence, it is the submission of the defense that this case is not admissible before this honorable court. Secondly, the war crimes charge were not committed in Missouri. And lastly, Ms. Lucio Mongala did not bear individual criminal responsibility via aiding and abetting. That would be the case for the defense. Thank you, Your Honors.
Thank you, Counselor. Now are going to deliberate. Mr. Saleh, do we go to the breakout room?
Ms. Adeke is supposed to move us to the judges' room.
Yes, moving to the judges room.
I am still in the main room.
I just sent you an invitation. Just a minute. Let me resend one.
Shouldn't you stop the live streaming first before sending us to the breakout rooms?
No, it's okay. I won't be joining.
Okay. All right.
Is that okay? Okay.
Well, I think we're all here.
Yes.
So,
before I proceed, Madam President, please, participants, could you open your cameras?
okay.
We are
Well,
waiting for the
first,
defense.
really?
Yeah.
I think I saw them.
They are here. They are trying to connect their audio.
Okay.
Because if we start giving the comments, I don't think they will hear us. So let's give them a minute to connect their audio. Okay, defense, could you open your camera?
I don't think we are audible to the defense because the audio is not connected.
They have connected in two devices. The defense.
Oh, I see.
The defense, could you, can you hear us? Defense team, you're muted.
The audio is still connecting for them.
Well, they have two devices on. So one has connected the audio, the other one is still connecting. Okay. They are now here.
Hi, the defense team can hear us?
Yes, we can hear you.
Okay, perfect. Well, thank you for these rounds. It was a very interesting and very intense as well rounds, but you all did a great job. We're going to introduce ourselves and then give you some comments, and at the end, we'll tell who the winner of the round is. So if we can start, maybe Miss Nilam.
Yes, thank you. Hi, my name is Nilam Andalia Kurniasari. You can call me Nilam. I'm from Indonesia, from Airlangga University, the Faculty of Law. It is a pleasure for me to be able to judge these competitions. And to both team, I would like to congratulate you because you are already made it to this semi-final round. Congratulations to both of you. But of course, in a competition, there should be one team which proceed to the next level and the other not. And later, after these deliberations, the presiding judge will announce who is the winner for this round. And first of all, I would like to make comments on your performance. Both team has already demonstrated a good competition round, and also both teams has demonstrated and delivered good arguments. However, regarding the basic basis of international law, I think both of you needs to work more. So please do not concentrate on the issues, only on the issues of war crimes, only on the issues of um, jurisdictions, but also do not forget to the issues of such as sources of international law. My previous questions to both of you, if I'm not mistaken, I asked regarding the ICRC commentaries, what are the status? Well, basically, I'm making reference. I was hoping somebody directly answers to me what's the status of this ICRC commentaries. Are they in which part of international law is this? Is this sources of international law? If yes, based on what? And if not, why? So you still need to work on the basis answer. Do not forget that the basic answers, sometimes it works. And for both teams, perhaps you need to work more on your performance of convincing, convincing other persons, other side of the conversations. So in this case, you need to convince the judges. Convince the judges that your argument is the best arguments compared to the others team. So what happened is that try to make eye contact. I know it is very difficult to make eye contact while you are in online environment. But what I can suggest is that concentrate on the camera. And if you are not able to do that, look at yourself on the screen. Okay, look at yourself. So this is more these tips sometimes helps. And if you encountered for example difficulties in internet connections and stuff, perhaps you might want to ask permissions from the judge to turn off your camera. I don't know whether this is allowed or not. Just sometimes just 1 minute turning off the camera can help, because camera is very heavy in consuming internet connections. And you might do this by the permission of the presiding judge. But of course, always ask permissions, whether it is allowed or not. And also regarding the voice for the defense team is that if you use these headphones, try to speak louder. Try to speak louder than usual, because sometimes I have difficulties in hearing you. So perhaps you might want to consider looking at the check your audio settings on your Zoom, and try to maximize the speaker, the microphone. the volume of the microphones. And also, if that doesn't help, then might consider not to use headphones. That will be better. And yep, I think that's all I want to make comments. And I would like to give the floor back to the presiding judge, Catherine.
Thank you, Ms. Nilam. Then Mr. Swale, if you want to continue.
Thank you, Madam President. For purpose of introduction, my name is Swale Hemed Wengo. I'm sure majority of you, almost everyone has seen my emails. So I'm the Vice President and Director of Operations and Logistics at FIS. And I'm also a lecturer of law with specialization in public international law, international humanitarian law and human rights, international criminal law, as well as investment law and arbitration. And I am the author of the Moot problem. I'm sure participants could tell from the questions we had back and forth. So one thing that you need to know is I was an observer judge, so I was not involved in terms of the decision. So it's only Madam President and Nilam who are involved in the decision and the outcome of this, because of the what. So I was more of an observer judge, and that is as a result of being the author of the Moot problem. So I have comments for each of you. For me, I'll be specific to each individuals. So I'll start with the first prosecution counsel, Mr. Sunday. Mr. Sunday, one thing I liked about your submission, and that comes also to your colleague, is that the way you cited the cases, it was full citation of cases, the parties, the court, the year, the specific paragraph. That was really brilliant, and that shows the amount of work you have put into this. Believe me, I know I have been in your situation more than 15 times across the world, so I truly know what it takes and the sleepless nights that comes as a result of that. So I was really impressed by that. One thing that you need to go back to the drawing board and address is the question of classification of conflicts. I know your argument was on admissibility, but we tried to push you in and out of that in terms of admissibility. So go back and look at admissibility, go back and look at the question of classification, which also leads to my point in regards to the second oral list for prosecution, Ms. Nasije. The classification issue was up and down, front and back. So I know with you too much questions. It's part of the process, and it's not just part of the process, it's part of the engagement. So don't take it in a bad way for all the participants. When questions are thrown to you, it means the judges are following your submissions. If judges are quiet, it means maybe they don't even get what you are submitting. But when they throw questions like that, that means they're following your submissions. And sometimes it's for clarity purpose, sometimes it's just to give you guidance. So you need to look at that. And also I liked the citation of cases as I indicated. Go back to the drawing board and look at the question of terrorism that was posed, the question of blocking, and what the ICRC interpretative guidance does indicate. That actually goes to both the prosecution and the defense. In terms of that document, you need to read it its entirely and understand what it is. It's part of the batch of documents that was given to you during the time of the organization of the Moot. So that is it. Then the last thing I want to raise on Ms. Nasije is it's not about finishing their submission. It's about doing justice to whatever you have an opportunity to submit. So you should be mindful of your speed. Don't rush too much because you want to finish, and don't worry about that, because of course judges have interrupted you too much. So it's expected that you automatically will not finish, but whatever you are submitting on, you have got an opportunity to do that. Just take your time to be able to make sure that you do purposeful justice to those submissions. And that's all what it matters. So we do not judge the case, we judge your knowledge of the law, the facts, your, of course, organization, and the composure you have, and the mode of presentation and persuasiveness that you have. So that's also something that you need to take into consideration. For the defense, starting with Mr. Yusuf. Mr. Yusuf, one, I like the way you are calm, even with questions coming. Sorry, are they here? Well, I see they're connecting again their audio. So that means they're not hearing my point. So let's give them a minute because it's important for them to hear these comments.
Okay.
Okay. Could the defense confirm that they can hear me?
Yes, can hear you.
Okay, great. My point in regards to the first oralist for the defense, Mr. Yusuf, I said I like the way you are calm. The calmness in you is really something that most people usually have a hard time, especially when questions starts coming in. You know, keeping your coolness sometimes, you know, you get that distorted that they're asking me too many questions. What's wrong with this? Then you get not to be calm. So that's really an important aspect in terms of the calmness. I liked it. The problem was classification of conflicts. So it seems like both teams had a problem with this issue of classification. And you saw that the issue of classification costs your colleague in terms of when she came to make her arguments, because then she was put on a wall to justify it. Of course, the judges have read the facts. Yes, I might have written the moot problem. Of course, I would know what is what, which one comes which one. But even the judges also have done that. So you should be mindful in terms of making sure there is a coherence between the two of you. That's one of the biggest challenges that your team had in terms of coherence, because now there was a contradiction between the first and the second oralist. So you need to be mindful of that. You also need to, in terms of case laws, I think you should adopt the style that the prosecution were using in terms of giving full citation. Because if you make reference to Tadic, which decision? Is it the pretrial chamber? Is it the confirmation of charges decision? Is it the admissibility of evidence decision before the pretrial chamber? Is it the trial chamber? Is it the appeals chamber? Which one? Okay, so you need to make specific reference to the case law with full citation of the case law in order to be able to guide the judges. For Mustafa, of course, I indicated that you were able to have a lot of questions come as a result of what your colleague had submitted, and therefore you need to work together in order to make sure that there is no contradiction between the two of you. Lastly, on the rebuttals, answer rebuttals. So my advice to the prosecution, rebuttals are usually short and precise. Don't make long rebuttals. You need to choose the strongest points of the defense. 2 or 3, maximum 3. I don't think rebuttal should even have more than 3 points. Okay? Pick the strongest. Of course, you cannot resubmit again the whole of it. No, pick the strongest points of the other side and you just attack those points. They submitted this. This is the proper position of the law. This is the proper position of the facts. Okay, so you need to consider that. Okay, the SAR rebuttal. So the SAR rebuttal, I like the SAR rebuttal because it was direct response to what the rebuttal was being made. So otherwise, I wish you the very best of luck. And whether or not you progress or you don't progress, do not take this as a do or die situation. This is a learning process. Whatever you have acquired here is going to help you in future. I can tell you that for sure, because I have been in your situation and I know what I have benefited out of this. And therefore, take it as a learning process, and that's sportsmanship. Of course, we have to finish the moot. So there must be one team that will progress. And therefore, that's all from my side. Madam President, over to you.
Well, thank you, Mr. Sualde. Well, my name is Catherine Peña. I'm from a small country in Latin America, which is called Colombia. I've participated in the 2020 JESUP and in different other moot courts of international law and especially international humanitarian law. So I've been in your place and I know this isn't easy. And I wanted to congratulate you for, first of all, taking the chance of doing this competition, and second, being also like so engaging, because I know engaging is not easy, especially via web, like via these devices that we're having in the competition. So congratulations to you all. I will give a general feedback because the other judges have been very clear on the feedback. So for the prosecution team, one thing that I would really like to highlight is like your passion towards what you were saying. I did really feel that, and I wanted to congratulate you on that. I think that you were really passionate about what you said. You were trying to make all your arguments, and that showed. So congratulations on that. And for the defense teams, I would like to congratulate them on their pace. I feel like even though, you know, virtual connections are hard and difficult, and I'm sure that you were just trying to connect and trying to verify that we were seeing you and we were hearing you. I think that you all handled that situation very well. And also for your pace, I really enjoyed your pace. So there are, like, I noted 3 points that are general feedback for both teams. The first one is Q&A. So be very careful. My advice for you is to be very careful and listen and notice what the judge wants. It's not just to show them that you know, but is to really do pay attention to what we are asking and like identify everything that we want to know that you know. So be very careful on that, on really paying attention to the question and giving us and knowing how to read the judge to know what they want from you and from your answer. The second thing I would think that it's something that you both teams need to work on is time management. You are at the first, you say how much time are you going to spend doing this or that, and so you need to be very careful on following that time. That also shows the judge that you know and you're prepared for what you're trying to say. So my second thing that I think that's very important for you to work on is time management. And the third one that I think is very important is to remind yourselves that this is like the formalities of the contest. So how do you address the judge, how you say, how you answer questions, how you address your colleague, if you don't know an answer, how to say no, maybe without saying I don't know. But all those formalities I think are very important, and I think both teams need to work on that. But other than that, congratulations. I think it was a great round. We both know you, both teams know, like your knowledge of the case and of the law was clear for us. So thank you for all your preparation. I know this is hard work. I know there's plenty of time spent on this, and I do think that you all did great. So congratulations. And now it's the part where I announce who the winner is. But I wanted to let you know, and I will repeat again, that you both did great. So this was a great round. Just there were just a couple of things that maybe one team had a little bit more stronger than the other. And the team that moves on is the defense team. So congratulations to you both. And we'll be very paying closely attention to the final of the contest.
Thank you very much, Madam President. I will invite the FIS President, Mr. Bukarim Aziz, for a few words.
Thank you so much, Mr. Swale. On behalf of FIS, I want to especially appreciate the judges for a job well done, starting from Madam President. Thank you so much for your time. Thank you so much for building African scholars. And thank you so much for your feedback. To Professor Nilam, thank you so much. We've been together since morning, and so we understand the commitment, the sacrifice. We appreciate that a lot. Thank you so much. To the Vice President FIS, Mr. Swale, thank you so much for bringing together these young African scholars and giving them the platform to showcase their talents and also to make them better by bringing in experts across the world, to judge the moots round. So thank you so much for the time, for the organization. We appreciate. To the coaches supporting the participants, thank you so much for a great job. We've seen, the kind of talent you've managed to build over the last 2 weeks. And we sincerely hope that you're not going to stop with training and coaching them and ensuring that they become better individuals as they leave the university. Thank you so much. To the participants, you've heard from all the coaches, you've heard their feedback, and you've heard especially from Mr. Swale. This competition needs to end, especially from the organizing part. We need to rest. And so it's not for us, it's not about winning or losing. It's about giving you the platform. It's about ensuring that you are well experienced and exposed to most of the happenings around the world and especially in Africa. And so you've managed to do that. To represent your university is a win on its own. And then to manage from the preliminary rounds to rounds of 16, to rounds of 8, and then to rounds of 4. You've actually achieved a lot. It's a success. So these stages, it's a success, and if you say it like that. But most importantly for us, it's for you to be able to network with participants from across universities in Africa, network with the judges, ensure that, there are things you want to do in Indonesia. You will find Professor Nilam there. There are things you want to do in the UK, anywhere around the world. We have just judges that will assist you. You have something to do, you find Judge Catherine, you need recommendation based on what they've seen. They can actually recommend to any university for postgraduate, for scholarship, because they know that you can deliver and you have the ability and the capacity to do some of those things. So for us, it's more than mooting. Is to open up, the opportunities for all the participants, so that the African continent can have so many, scholars who understand conflict management, conflict resolution, and in the case there is a conflict, you understand the IHL principles on how to manage conflicts. And so I want to thank all the participants for a job well done. On behalf of FIS, this is where we'll draw the curtain for today. Okay, I'm seeing our country coordinator for South Sudan, Mr. Daniel. Thank you so much. Our media manager, that is Adeke John Mary, who has been the clerk of the court.
Mr. Karim, are you there? Okay, I think Mr. Karim is disconnected. Now I'm just seeing a message from from the defense. They said they didn't hear which team has progressed.
They should put on their camera.
Can you confirm your existence, defense team?
Yes, sir, we can hear you now. We lost our connection.
What about your camera? Can you put it on?
Are you able to put the camera on?
No. Okay. Yes, sir, we can hear now. We lost our connection back then.
Okay. May I humbly plead to Madam President of the court to make the announcement again?
Sure. The team that moves on is the defense team. Congratulations.
I don't know if they had that. Defense team, can you confirm now you had?
Yeah, sir, we can hear you now, but we didn't particularly hear you.
Did you hear what Madam President said?
No, sir, we did not.
I just said that you were the winners of the round. So congratulations.
Thank you very much, ma'am. Thank you very much.
Okay, so as indicated, so the defense team, please do not leave this room after this. So you should remain here. We have some few communications to make in regards to the finals for tomorrow. So please stay in here. To the judges, thank you so much for accepting the invitation and taking your time to be here. I know I disturbed you quite a lot with too much emails, but that's part and parcel of the jobs. But otherwise, I thank you for taking the time to be here. For the prosecution team, believe me or not, I liked your submissions. We liked your submissions. It does not matter the outcome of this. It does not mean that you are bad. No, it's just that, of course, we have to pick, not we, they have to pick one of the teams to go to the final so that we can then finalize with this. But otherwise, I wish you the very best of luck. Please keep in touch. There's a lot of opportunities out there. If in case you want to link up with any of the judges you meet, please let us know. Then we can be able to connect you, and then we can have further engagements. And whatever has been provided, this is to all the teams, whatever has been provided for in this mode. This is current discussion that is ongoing in terms of regulating autonomous weapons in armed conflicts. There is a discussion at the UN in Geneva that is on having whether we should have a treaty in regards to this. So you can make your contribution, use that knowledge, publish articles, publish blogs on it, or make any other contribution that you can make in regards to these current issues. And therefore, this is not the end of it all. Thank you so much. At this moment, I wish you the best of luck. See you when we see each other. Ms. Adeke, you can stop the live.
I'd like to congratulate to FIS for conducting this successful competitions. Congratulations to FIS.
Thank you
so much, ma'am.
So as indicated, we are live tomorrow for the finals at 11 a.m. on YouTube. That is 11 a.m. Kenyan time. Ms. Adeke, if you